Your Honor. Good morning. So at this time, the defense would be moving for a mistrial based on the evidence that has been presented so far. This is based.
Mistrial?
Yes. And this is based on the evidence that was presented in the prosecution's case in chief. And we believe that the evidence presented will prejudice the defendant to the extent that the fundamental goals of accuracy and fairness are threatened by allowing Mr. Stoughton and Mr. Bloomfield to opine on standards that are not applicable under Michigan law. As they both admitted, they don't know what Michigan law is, and that are not within the knowledge and in the situation of the arresting officer, based on tactical considerations that are not ultimately at issue in this case, including everything that led up to the ultimate issue here, which is whether Officer Schurr had an honest and reasonable belief to be in fear of death or great serious bodily injury at the moment that he made the decision to use deadly force. We also, based on their testimony, it's clear that they have not relied on proper training. They were relying on outdated policies. They were testifying about a taser model, an old taser model. They were not qualified as taser experts, and they gave several opinions about the taser. And at this point, we believe that we're too far along with the jury to simply strike their testimony, because they have heard testimony from two of the people's experts now that do not accurately, and are not nowhere near based on what the law is in Michigan and what should be considered in whether or not Officer Schurr was justified in using deadly force. And so at this time, we would move for a mistrial on that issue. And if the court is not inclined to grant the mistrial, then we would be asking that their testimony is struck from the record. Although we don't think that would be enough, because they've heard too much now based on the tactical considerations. And under Supreme Court precedent, San Francisco v. Sheehan, the 2015 case, even under the Fourth Amendment, that it says even if the officers misjudge the situation, the court cannot establish a Fourth Amendment violation merely on bad tactics that result in a deadly confrontation that could have been avoided. Courts must not judge officers with the 20/20 vision of hindsight. And they're quoting Graham versus Connor for that issue. So we'd be moving for a mistrial on those grounds. And alternatively, we would also be moving for a directed verdict based on the motions that we just filed with the court. Given the complexity of the case, we would ask the court to review the written motion that we filed before making a ruling on that and before we move forward in our case in chief.
Mr. Becker?
We haven't got a copy of the motions, so that may be nice if we got one too, but I think there's no reason to grant a mistrial because they talked about objective reasonableness. Of course, we talked about this over and over again in chambers that objectively reasonable officer, and we made sure to stick with that standard through the testimony of the experts. So there's no basis. And the experts can talk about Michigan law. The law is up for the judge to instruct on. So to say they weren't talking about the law, that's not their role to talk about the law, in terms of the law. That's the jury's role in terms of determining whether somebody's engaged in self-defense, and that's a question for the jury. So they stay away from that. There's actually no grounds for mistrial.
Anything else in this? Everton?
The only thing I would add is while they were testifying, they were talking about the laws and policies from other states. They were talking about what applies from the International Association of Chiefs of Police. They talked about all of these other agencies from New Mexico and South Carolina that is not grounded or not required under Michigan law. And we outlined that in our trial brief with and attached 4 declarations explaining that that is not something that Michigan law requires or that GRPD trains their officers.
Anything else?
No, Your Honor.
No, Your Honor.
Okay. So, I'm prepared to rule on the motions for both the mistrial and the directed verdict, which incidentally, as soon as we left the courtroom, I did receive the motion, I did review the motion, and I'm prepared to move forward. on both of those at this point. I still give you a break if you need one after, but as far as a mistrial is concerned, I do not believe that the expert's testimony rises to the level of requiring a mistrial. I believe that the fact that they were testifying, they clearly were testifying on generally accepted police practices. They never held themselves out to be experts in Michigan law, and as Mr. Becker stated, it's the judge's role to instruct on what, on what the law is, and it was the expert's job to provide opinions based on how they apply the facts in this case as they have been presented thus far to reliable principles and methods, and I believe that they did that. So, and I believe that the fact that they did not testify based on what Michigan law is, that more so would perhaps go to weight to the extent that it does not agree with what I instruct the jurors on. Also, it's ironic that you cited a Supreme Court case because obviously the Supreme Court is the court of the land, and the experts were testifying based on generally accepted police practices nationwide. And so, given that, I don't believe that their opinions or the fact that the juror heard those opinions would rise to the level of prejudicing the defense or the defendant to the extent that a mistrial should be, that I should declare a mistrial in the case. And as far as the directed verdict motion, obviously, as everyone, well, all the attorneys know, that a directed verdict of acquittal is only appropriate if after I consider all of the evidence presented by the prosecution in a light most favorable to the prosecution, I would have to determine that no rational trier of fact could possibly find that the elements of the crime charge were proven beyond a reasonable doubt. In this case, there are essentially three elements. The first is that the defendant caused the death of Mr. Leoya, that Mr. Leoya died as a result of a gunshot wound that was fired from the defendant. I believe that is obviously clear. It's on video. No one is disputing that the defendant caused the death of Mr. Leoya, at least not any of the witnesses that I've heard so far. So it seems clear that that element has been met. Also, that the second element is that the officer had to have one of three states of mind: that he intended to kill, intended to do great bodily harm, or knowingly created a very high risk of death for great bodily harm, knowing that that would be the likely result. As an officer at the time, he was clearly aware that if he put a gun to the back of someone's head and fired a round into their head, that would likely, that at least created a very high risk of death, if not evidences an intent to kill Mr. Leoya. So I believe that element, again, would be difficult to dispute given the background of the defendant as testified to thus far, as well as the video. That brings us to the only element in the court's view that is really in dispute here, and that is whether or not this killing was justified. It's clear that Mr. Leoya appears to have possession of the defendant's taser at the time that this shooting occurs. But it is also clear to the court that a rational trier of fact could find that the alleged victim, in this case Mr. Leoya, was not in a position to use the taser at the time that the shot that killed him was fired. I believe that a rational trier of fact could find that based on the video alone, but if you also incorporate testimony of not just the experts, but also other witnesses, including the witness that talked about the taser, Mr. Childs, I believe a rational trier of fact could find that the killing was not justified. And so, because that is the position of the court, I am denying a directed verdict of acquittal for those reasons, because I do not believe it to be appropriate under the circumstances. And so with that, is the defense ready to put on their case in chief?
We are, Your Honor, and I had a question. We were had some stipulations. I can't recall the court's preference on the stipulations in front of the jury, or should we just do those right now and then we can move right into
You mean stipulation to admission of exhibits?
Yes, and our first witness, so the court's aware, is our video analyst, and he's going to be playing a lot of videos. So the stipulations that we're looking for are defense exhibit C, C1, C2, C3, C4, and then videos J and K. And then an audio defense exhibit HH.
Okay, I think these are all similar videos, so I have no objection.
Okay, and C was already admitted, stipulated to at the beginning of the trial. So because there's no objection to the exhibits that you just listed, I'll state for the record that C1, 2, 3, and 4 are admitted. I'm assuming they're separate exhibits from C. Also, I'm admitting J, K, and HH at this time.
And yeah, Your Honor, just so, it's HH, two H's. I don't know if I made that clear.
HH.
Okay, I'm sorry, Your Honor. I don't hear that well.
All right, and I also received the defense witness list, so I have that printed out as well, so that we'll hand that out to the jurors. And anything else before?
No, we're ready now.
Okay. And anything for the people?
No, Your Honor.
All right, so we'll have that in. And right after they come in, I'll have my clerk hand out the witness list. So you can